Hi, it's Pravinita Singh-Pillay, Principal Lawyer, Cornerstone Law Offices. Today I want to talk to you about generally what questions we get asked when we're having a discussion with our estate planning clients. So that's talking about your wills, power of attorney, and advance health directive. One of the questions that we typically get asked is who to appoint as the executor, or well, that's a question we ask them, is who will you appoint as the executor or trustee of your estate to look after your interests and to give effect to what you've said in your will. It's someone that you should be able to trust, that will do the right thing and actually comply with your wishes. So think of your children, your adult children or family members. The difficulty some people face would be international migrants living in this country who may not have close relatives here. As it is ideal to appoint someone locally because at the end of the day, it's cost effective for your estate if someone is available locally to speak to a lawyer, to sign documents, etc. If that's not an option, that's fine. You can appoint your international relatives. The other one is typically if people want to exclude certain family members from their will. You'll have situations where parents don't wish to leave anything to a particular child, or I had a situation where they did not wish to leave anything to any of their children. And yes, so the short answer is it is your will, it is your estate, your hard-earned money and assets. Therefore, you're at liberty to leave to whoever you want, whatever you want in the will. What needs to be kept in mind is the reasoning behind it should be documented, either within your will or by way of a statutory declaration or an affidavit, so that that evidence is available in the event that it is needed down the track. When you've passed away and gone already, at least the evidence is there to explain to your loved ones or to a court if your estate is challenged as to why you chose to exclude certain people. The other question we get asked is, okay, we can afford to make a will, but we really don't want to make an enduring power of attorney because that's not necessary, that's fine, my family will just make decisions for me. That's not the correct approach. At the very minimum, my advice is always to make a will and enduring power of attorney. It's a bit late when you've had a stroke or some tragedy has happened and you're in a coma, then to be thinking about should you have made a power of attorney. It's important to have the document in place so that in the event the circumstances arise, you've made the document while you had the legal mental capacity to make it, rather than it being questioned close to the time whether you had the capacity to make it or not. So an enduring power of attorney is where you again appoint someone that you trust who will step in your shoes to make decisions about your financial and health matters. So again, appoint someone you trust. The requirement is they can't be your paid carer, they can't be your healthcare provider, and they must not be bankrupt. So you have a wide range of people that you can choose from, starting from your immediate family. You can appoint up to 3 people or more, and it's advisable to appoint at least 2 people so that if one of them either loses capacity or passes away before you, then at least there's a fallback. If you like this information, please share and like it amongst your network. If you have any further questions and wish to discuss options, please feel free to call us.